court, all rise. Please be seated.
Good morning. I have a series of questions from the jury. I've shared them with counsel. The note from the jury says, the majority of jurors are still undecided and we would like help with the following questions. Why was voluntary manslaughter offered in addition to murder? Sufficient legal provocation means, who does it apply to? What is meant by imminent danger? Define a forethought for murder. Is there a time frame, 1 second in the moment or a moment before? Is the idea of self-defense apply the same to a police officer as ordinary person? What says the state?
We're working on some proposals for you. I think that the jury is obviously still working, still deliberating, and still asking for guidance from the court. We handed up a case this morning, State versus Liederman, 249 SC 61, regarding the propriety of a court answering jury questions and providing further legal guidance. I think in this situation, their questions, I think this morning, are good ones, and that can be clarified using South Carolina case law, and we'd like to propose some ideas for you.
Mm-hmm. Says the defense.
Good morning, Judge.
Morning.
Judge, the note that was received on Friday is unequivocal. The statement of the unnamed, unnumbered juror reflects an understanding of the position of the court, but then states that that juror cannot, with good conscience, consider a guilty verdict. It's an unequivocal statement. Further, that position of that juror speaks in terms of plural, not singular, of other jurors which have a like position. The basis for that juror's position is based in fact and law in the statement that I still cannot, without a reasonable doubt, convict the defendant. The juror then reflects an emotional sense regarding his heart and what that emotional position would do with respect to the victim, Scott's family. Nonetheless, his statement or her statement is unequivocal once again. But with the choices, I cannot and will not change my mind. Now that juror has not been addressed. There's been no response to that juror. And the juror themselves has said the position of the court, reflecting their respect for the court and its admonitions. So we would respectfully at this time renew our motion for a mistrial. And reflect that this juror represents more than one party, as previously questioned. I think it's important to note that the jury foreman provided a sense that there was only a juror, or at least the court's interpretation of that statement indicated that perhaps there was only one juror. When that juror, the foreman stated that the person with the problem that wanted to leave was a singular person. Now, what's most interesting about this morning's note is it's not written by the foreman. It is signed with the number of the foreman, but clearly when one compares the handwriting of that person, it is unequivocally not the foreman. That raises further concerns about Friday's note in that it was sent directly to the court and not through the foreman, which may indicate that the foreman is not providing an equal opportunity for all members of the jury to have their say. Now, the unequivocal statement this morning is that the majority of jurors are still undecided. The questions that have been raised, question number 1, question number 2, question number 3, question number 4, have been answered by this court in its previous admonition of the law in the case. The question number 5 is the request that the defendant has made since prior to the start of this trial, which we believe is a key, given the facts and circumstances of this case, that the court should follow the laws established by the United States Supreme Court and repeatedly in the Fourth Circuit, regardless of the position, the questionable position of the South Carolina Supreme Court, with its confusing decisions with respect to a policeman's action in the line of duty. We think that the fact that this question is raised then gives even more emphasis on the request that the defendant has made repeatedly for an explanation that police officers under the law of the United States Supreme Court, under the law of the First Circuit, and believe as well the South Carolina Supreme Court, that they are treated differently and for good reason. The defendant's position then at this time would be to ask the court respectfully to reconsider its previous decision and declare a mistrial at this point, in that the court is aware that one or more of the jurors are unequivocally unwilling to vote for guilt in this session, and if the others do not go along with that, then we have a split jury decision. Now, the last question that's asked is answered in the Graham versus Connor case. In note 4, in discussing the reasonableness of the particular use of force. And Connor is quoted as saying, "The calculus of reasonableness must embody allowance for the fact that police officers are often forced to make split-second judgments in circumstances that are tense, uncertain, and rapidly evolving about the amount of force that is necessary in a particular situation." That is the United States Supreme Court's version on questions 3, 4, and 5 of whoever that juror is this morning, who raised those issues. Your Honor, we would respectfully request at this time that the court mandate a mistrial in this matter. Thank you.
All right, thank you. Says the state.
On which issue, Your Honor?
The issues addressed by Mr. Savage.
I think the court's already ruled on that and already given a principle of law on those issues, and I don't believe that that ground needs to be replowed. The Tennessee v. Garner, Graham v. Garner ground has already been argued, discussed, and decided by this court. And now certainly an appropriate time to change the instruction given to the jury regarding that. I think the court was right the first time regarding what our Supreme Court has said and what the state of our law is. I do, however, believe instead of coming up with an entirely new concept for the jury and an entirely different state of the law and body of the law, the court can answer this jury's questions by turning to South Carolina law and restating the law in another way. I understand that the jury has the court's written instructions, but sometimes hearing the same principle stated with different language, perhaps less formal language, but language sanctioned by our courts, to give the jury some more guidance. They're clearly asking for help, and help is available, and it's appropriate for you to give them help by restating some of the principles that they asked you about.
All right. Anything further, Mr. Savage?
Your Honor, we would vehemently object to any further instructions by this court unless the court would consider the common instructions that I had before.
Well, we discussed at length the other day what the court must consider in dealing with issues of a mistrial where the jury is deliberating, and where a jury indicates that further deliberations would be beneficial, then the jury is not deadlocked and the court should not declare a mistrial. The court instructed or informed the jury as to the law when a jury returns a second time without having agreed on a verdict, and part of that instructions of law that the court gave the jury is that the judge cannot send the jury out again to continue deliberating without the juror's consent, unless the jurors ask for further explanation of law. So in that connection, the court is, in some way, the law is designed to almost invite the jury to seek further explanation of law. If they need a further explanation of law, this jury, through its foreperson, indicated that they thought that further explanation of law would be beneficial, and they indicated that they'd have some questions this morning. And they appeared this morning with some questions, and it's obviously not a question of the foreperson, but questions by the jury. The fact that the note was written by, might have been written by one person on the jury and signed by the foreperson, follows the instruction of the court, and that is that any note submitted to the court must be signed by the foreperson. Importantly, the note says that the majority of jurors are still undecided. It doesn't say the jury is deadlocked, it says they're undecided, and that's what deliberations are all about, getting an undecided jury to decide. They've indicated that they're still undecided and they would like help with the following questions. Then they pose the questions. Now, reading reading the substance of the questions, it's not clear that they're undecided on the issue of guilt or not guilty or not guilty. But first questions. First question deals with the issue between murder and manslaughter. Second, the clearer definition of legal provocation involving manslaughter. What is meant by being in imminent danger? What is malice aforethought? How long must malice exist before a jury could conclude that the killing was with malice, which would be murder, or without malice, which would be manslaughter? And the question of whether self-defense applies to a police officer the same as it applies to any ordinary person. And we've spent a significant amount of time dealing with that, and the jury has a separate instruction involving the right of the police officer to use reasonable force, and that's force in effecting an arrest. But in regard to self-defense, in this state, there's only one law of self-defense. There isn't more than one. So the arguments made this morning that suggest that the court hasn't responded to the note of the individual juror who submitted the note on Friday would seem to suggest that the court should talk with that individual juror, and I think it would be inappropriate to speak to jurors individually during deliberations. That's why they're brought out as a group, and it would be inappropriate to bring that one person out and talk to that person, give them a talking to. That wouldn't be right. It's part of a jury, so I can't single out a juror and with a lecture or an explanation to an individual juror. During the course of the trial, it's a little different if they have issues regarding, I want to call my wife and things of that nature. That's a different perspective than having trouble during deliberations. The court is obligated to answer questions posed by the jury during deliberations unless the answers would be inappropriate based on an inappropriate comment on the facts of the case or in some other way add more confusion as opposed to clarity to the questions being asked. The preferred way of responding to a jury that submits questions, where possible, is to give a written response to the jury and to instruct them. They have a written jury charge. Many of these questions or answers to many of these questions can be gleaned from the charge, but at the same time they've posed questions that I believe can be answered. And I want to give counsel an opportunity to draft a charge responding just as you were given that opportunity prior to the original instruction. I've given you this question, I guess you've had about a half an hour now. Almost half an hour. You don't have too much time to draft a response or your proposed response, or you may not want to. But the court has to respond to the questions of the jury. I deny the motion for mistrial for the reasons previously stated, and I want to give you all an opportunity to contribute toward whatever additional charges given the jury.
What I ask, Your Honor, is that obviously we're moving on the fly, that we can draft you something, email it to you and to the defense team. Right now, we've been working before you came out on some proposals. So we can do that, send it to you, so you'll have something in writing to edit or disregard or do what you will. And the defense will have it as well. That's okay. It's not going to have a caption and all of the formalities that we normally would provide, but we think we can get you a good solid draft in just a few minutes.
All right. Mr. Savage?
Judge, with all due respect, and I don't want to re-argue what the court has already instructed, but with respect to the comments of the court, I would point out that if these questions are in fact about voluntary manslaughter, as we believe they are, then this jury has not obeyed the instructions of this court, inasmuch as this court has instructed them not to consider voluntary manslaughter until after they've determined whether murder is appropriate or not. So in order to ask this court questions regarding voluntary manslaughter, there must be already a finding of not guilty of murder, or they're not in compliance with the court's instructions.
It might be the belief of some and may not be the belief of others.
And the court has instructed them not to consider manslaughter until they reach a decision on murder. Furthermore, with respect to the juror who wrote to the court on Friday, we would ask the court to not talk to that individual, but to say generically to the court that all questions to be considered by the court must be signed by the foreman. I think that would address that particular juror's situation, but just ignore the concerns expressed by that juror may induce that juror to be somewhat coerced by the negative, by the lack of response.
I'd be happy to remind them that any questions or comments submitted to the court must be signed by the foreperson. And that's already included in the instructions. I'll reiterate that to the jury.
We'll confer and get our response to the court's inquiry as quickly as we can.
Yes, sir. All right, so we'll be in recess for how much time do y'all need?
15 minutes.
3 days.
All right, about 15, 20 minutes.